So welcome, everybody. I'm Judge Tour. If you don't know me, I think most of you know me, but really glad to have you here. And I'm just going to give you a brief little introduction, and I will come back later in the morning, and I'll be available to answer any questions near the end of the morning if you have any after the presentations. So first of all, have any of you, I know at least a couple of you, have done the clinic, have been here before, right? Several of you. Yeah, but how many of you have never seen one or been to one in any way? Quite a few. Great. Okay, good. So I guess I would start out just by saying that I think it's fair to say that most of us in this room are very lucky. The fact that we're in this process, that we have a lot of lawyers here, court staff. I think all of us have jobs, obviously, homes, hopefully enough food, a car, most of us. But there are amazing numbers of people in Vermont living in poverty. I have to say I had no idea how many before I became a judge. It's a whole different world that you're exposed to in this role. And for some of those people, it's due to long-term problems like mental illness, substance abuse, drug or alcohol addiction. For some, it's temporary. It's because of illness, job loss, divorce, domestic violence, things like that. But it is quite amazing how many people are so close to the line that they can't come up with $100 or $200 sometimes to pay their rent to stay in their apartment. So many of these people end up here in court. They're not all quite at that level, but many of those people and others who are having these challenges end up being in the middle of eviction proceedings here. Also, many landlords are represented by lawyers, and most tenants are not. The statistics from a few years ago, which I think are probably still pretty accurate, were that 75% of landlords in Vermont have lawyers, and only usually 10% of tenants did. Now that's hopefully changed somewhat due to these clinics, and it varies around the state. I would say in Chittenden County a higher percentage have lawyers. I've been in other counties where there are many more unrepresented landlords, so it does vary depending on the geographic location. But the playing field is very uneven overall. Vermont Legal Services, previously Lawline, I have to keep remembering to do that, does assist tenants who seek them out before these hearings, helps them to file answers, gives them advice, but it really is not the same as having a lawyer in the courtroom. I can tell you as a judge, no matter how many forms and how much information you give someone who is not a lawyer, they are not going to do as good a job in court as a lawyer would, and they do not always understand it. It also means that to get that assistance, tenants have to know that there is a place to go before their hearing, and they have to proactively reach out to get that help. And many of them don't know that. So this clinic is just for rent escrow hearings, and I'm just going to tell you a little bit about what that is. The first step in many eviction cases, not all, but in many, is for the landlord to file a motion to escrow rent, or also a motion to pay rent into court. They're usually filed with the complaint, although not always. And if the landlord knows what they're doing, they will get the hearing notice from the court before they serve the papers, and it gets served with the complaint. Sometimes it has to get served later, especially if a landlord makes a choice not to get it, to file that motion until later. A lot of pro se landlords don't understand this. They file the complaint, then they come in and they ask for the hearing, and then they have to pay the sheriff a second time. But the bottom line is a notice goes to the tenant that they have this hearing in court. And we've tried to make the hearing notice understandable so that they know that it's important. But nonetheless, there are a lot of tenants who don't show up at all for the hearings, whether because they're panicked, they didn't read the paperwork, they know they're in trouble and they're just hoping it'll go away, which is the way a lot of us deal with problems. But a lot of them do show up. And the hearing, that particular hearing, is limited to deciding whether, when, and how much a tenant has to pay into court to stay in the apartment while the case is proceeding. And the kicker is that even if the tenant has good defenses, even if they might be able to prove at trial that the landlord provided a terrible apartment, it didn't have heat, et cetera, once a rent escrow order is issued, if they miss a payment, they can be evicted almost immediately upon service of that order from the court. It's a very quick process if you miss a payment. So people who don't come, they don't understand the significance often, and we get motions later, which you don't have to worry about today. But at the rent escrow hearing, it's a really important order that's coming out of the court for people's housing. And that is why I think this stage of the proceeding is where we felt that, a really targeted program of having lawyers available is really significant. I'm just going to quote something from one researcher who's done a lot of work on evictions. Says the following: because landlords often turn away applicants with recent evictions on their records, evicted families regularly experience prolonged homelessness and increased residential mobility. When they do locate subsequent housing, they frequently must accept substandard conditions in disadvantaged neighborhoods. Evictions often prevent families from qualifying for housing programs, past evictions and unpaid rental debt being counted as strikes against those who have applied for assistance. Studies have linked eviction to psychological trauma and have identified it as a risk factor for suicide. Recent research has found that mothers who were evicted in the previous year experienced more material hardship and were more likely to suffer from depression compared with those who avoided eviction. And that's from Matthew Desmond, who has also written a book I highly recommend called Evicted, which is pretty horrifying. Things are worse in other places in the country, but definitely recommend reading that if you're going to do this work. Also, Vermont Legal Aid just issued a report in January on evictions in Vermont. Is this something you're providing to people or not?
No, it is available.
It is available online,
but
right?
I can also provide it afterwards.
It's online, I think. I found it there initially. It's really, really a great report, worth reading, very, detailed about Vermont in particular. And I think we have the cover boy in the room, do we not? Do they call it cover boys like cover girls, right? You want to sign my copy later? But it's got a lot of detail, and it'll give you more information. But that report also notes the same point that, having an eviction can make it much harder to find another place. It talks about, the impact on children who are pulled out of school. I mean, imagine trying to do your homework if you're living in a car or in a shelter. It's got to be incredibly challenging. It also notes that nationally, 40% of the people in homeless shelters are there because they were evicted. And talks about the cost of, all the services and government benefits that have to support people in those situations being much higher for society overall than keeping the tenants in their housing. And I'll just add that, therefore, one of the recommendations in this report is for the legislature to allocate more money for funds to help people pay their rent if they're not too far behind. So that's something I strongly support. Also, there was just an article in the Boston Globe that talked about the fact that this is, I've read before, this is a problem all over the country, and everybody's struggling with it. But I noted in the article that it said that New York City and San Francisco have recently established a right to counsel for low-income tenants fighting eviction. I don't know if that's accurate. It was newspaper, but I really think that's the direction we should be going in, ideally, if we could really have lawyers for everybody. My wish, actually, is that everyone who comes to court in every kind of case would have counsel. It's what's referred to as civil Gideon, and if you haven't heard of that, that's worth Googling too. There's a lot out there about that. I feel strongly that when people are threatened with loss of custody of a child or their home, their business, whether they're plaintiff or defendant, that people should have lawyers if we can make that happen. But we do not have that now, and so this project is here to try and address that problem. However, I want to make clear the project is not just for the benefit of the tenants. Rent escrow hearings are also very important for landlords who sometimes depend upon the rent money to make their own mortgage payments or other living expenses. Often, the landlord, I see this all the time, the landlord has really tried to help the tenant by letting them, go another month with the promise that they're going to get the money, and it goes on for a long time because they're being kind to the tenant. But at the point they come to court, thousands of dollars are owed, and the landlord is really stretched too. Also, although, in a landlord-tenant case, you can both get an eviction and get a money judgment when money is owed, the reality is a lot of the landlords are never going to collect that money judgment because these people just don't have the money. So it really matters to them to get the income flowing again by getting the apartment open so they can get someone else in there, particularly in a case where trial might be months away. And the court has denied a rent escrow order or reduced the payments for whatever reason, an earlier resolution can be a huge benefit also to the landlord. Also, even if the rent escrow is being paid regularly, remember it's coming to the court. It is not going to the landlord. unless the tenant agrees that the court can release it. And that does happen. There are times when the tenant says, I totally owe the money, yes, you can give it to the landlord every month or something like that. But if the tenant is really disputing the case, it's their money the court is holding until we have a trial to decide who should get it. So the landlord is still not getting anything coming in during that time. So this project is intended to get all of you some time in court and some experience, while at the same time helping people who are living on the margins of homelessness and can't afford a lawyer. If, as a volunteer, you can keep a tenant in her home or help another tenant get time to find a new place without ending up on the streets or in a shelter or a car, you will be doing that person or that family a great service. Sometimes you'll see a flaw in the landlord's case that can lead to dismissal of the whole case, or defenses that can succeed or at least reduce the amount of rent that's owed. Now, often you will find that the tenant just does not have the funds to pay the rent for whatever reason and really has no defense at all. However, there are sometimes funds available from COTS or other sources to get tenants caught up, and just helping point them to those sources might make a huge difference. That can be a big win for the tenant and for the landlord if they get all their money. In addition, even if the eviction is inevitable, there are many things that can lead to a better resolution for both sides. A negotiated move-out date, backed up by a court order, a writ of possession for that date, can give the landlord certainty and the tenant more time than they might have if they missed a rent escrow payment. A deal for the landlord to waive the money owed in return for the tenant leaving sooner than might happen with a trial can also get the landlord the apartment sooner with the ability to get a paying tenant in, and can avoid a money judgment against the tenant. Sometimes, although rarely, you may be able to even negotiate a payment from the landlord to help the tenant make the security deposit or first month's rent on another apartment so they can get out faster. An agreement that the case will be dismissed if the tenant leaves by a certain date can avoid an eviction judgment on the public record, which can make it harder for that tenant to get an apartment in the future. An eviction can also disqualify someone from getting Section 8 housing, which is a huge thing. So, as I said, I believe better outcomes can be reached for both sides, and I think you'll hear about that from the landlord's lawyer that we have here today. I think she'll agree with that, and you'll hear some of that from Nadine. So, what are we asking you to do? The only commitment we are asking is for you to come to court for the rent escrow clinics that are scheduled, block scheduled at a certain time. How many times a month?
Twice.
Okay.
3 times.
Michael is the clerk here who does all of this. He's an important guy to know, Michael Stowe. So your commitment is just to assist with those hearings, and you don't have to keep the case after that. You don't have to file motions after that. You can keep the case if you choose to, and that's great. Sometimes volunteers do that, but we don't expect it. We do want you to advise the tenants about what the next steps are after that hearing if they appear to have defenses that should be raised. Advise them to work with Legal Services, what's the new name?
Legal Services
Legal
Vermont.
Services, to prepare an answer or motions. If you don't want to help them with that, at least make sure they're talking to someone about that. They do get 2 weeks to file an answer if they show up for the rent escrow hearing. It's extending the answer deadline. So we want you to point them in the right direction at least. And there will always be somebody here from Legal Services to help you with the next steps, and also to answer the complicated questions when something crazy comes up that you don't know anything about. I hope some of you will choose to assist the tenants filling out the paperwork for answers and so forth, but there are forms that will be provided to help you do some of that. I should say the forms that we have for anything that's provided are not blessed by the courts as official forms. They were created for the project by Legal Services, but you can use different forms if you want to create your own if you're doing this a lot. I should also add that some of you know that my usual rule is to start hearings within 5 minutes of the scheduled time, even if somebody hasn't shown up for one side. But for these clinics, I'm very loosey-goosey about the scheduling. It's a lot of negotiating going on. You have a limited number of landlords' lawyers, so they often have multiple cases. They need to talk to multiple different lawyers for the tenants. I know that we can't keep to a schedule, so it's totally different on Landlord-Tenant Day, and I'm good with that. One other issue that's really important to lawyers, and that is conflicts. Rule 6.5 of the Rules of Professional Conduct gives a special protection for court-sponsored clinics like this. It says that you don't need to do conflict checks the way that you normally would. Instead, you can proceed to represent the tenants at a clinic like this unless you realize that you have a conflict or someone in your firm does. So if you walk in and you see the person and you say, oh, I know, I have a conflict, that's something you have to take action on. But unless you know it, you don't have to do anything. And the rule makes clear that by representing someone through the clinic, you don't create a conflict for your firm either. So you probably want to read that rule yourself, 6.5, but it does make these things a lot easier than they would otherwise be. So I want to thank those of you who are willing to volunteer. Even coming to the training doesn't commit you to volunteering, but I hope you will all decide to do that. We do have a sign-up sheet at the end of the training for those of you who would like to. There are dates, I think, for 3 months, something like that? Through June that we need people for. So, if you want to do it, but you're nervous and you want to learn a little more, you can sign up for the later dates, but please consider doing that today. Once you do volunteer, you'll be added to the email list. You'll get notices for future dates and asking if you can sign up for any of them. Also, if you do volunteer, or even after the training today, if you don't, if you have any feedback about how you think the project could work better, I am very happy to hear it. I'm sure Maggie would be happy to hear it. We want to make it work for you. If there are reasons that you wouldn't volunteer because of something, let us know what that is. Maybe we can find a way to make it better. I also want to note that in this county in particular, but all around the state, I think, we have some really wonderful lawyers who represent landlords, such as Nadine, who are really willing to work with the tenants when it's appropriate to do that and try to find solutions that benefit both sides. Not every lawyer has that approach, I will say, but generally speaking, I think we're really lucky in that regard. And it's a really great asset about Vermont is the collegiality that we have, even when people are on opposite sides of cases. So a big thank you to them, as well as to the lawyers from Legal Aid and Legal Services who make this program work. Maggie does a huge amount to coordinate everything. We have other people like Angel Court, David Santos, who are here all the time. It's really, it would be impossible to do this without all of you. And the paralegal that I just met, she probably does all the work. I don't know.
Take
But
credit.
we do really appreciate that. And also the court staff like Michael, who does a huge amount of the paperwork in all of these cases, with a smile every time, even when it's really crazy. So the court officers aren't here to thank, but they're also wonderful. And if you have any questions, they're usually available to help. So any questions before I step out and let the real training begin? Okay, so as I said, I'll be here later in the day. And if you have anything you want to ask me about at the end, I'm happy to help out. Okay?
Thank you.
So have you all met Maggie and Nadine?
So I'm Maggie Fry. This is Nadine Seebeck.
And you're going to do the bulk of the training, and then we have some, at least one other person later in the morning, right? Okay.
Exactly.
So good luck.
Thank you. Good morning, everyone. So that was a great introduction from Judge Tor. She actually talked quite a bit about my next 3 slides, so I don't have to spend as much time on them. But just a brief word about the clinic. So the clinics actually exist in now 4 counties. They started in Chittenden County 4 years ago as sort of a pilot program by other staff at Lawline, really primarily Tom Garrett, Angel Court, David Santos got that project up and running. And then Legal Services Vermont, which is funded by Legal Services Corporation in Washington, D.C., gave us a grant to take that model started in Chittenden County and expand it to other counties in the state. So we are now up and running in Addison County, Rutland County, Washington County, and of course the Chittenden program is still going strong. And Vermont Legal Aid is doing a couple of smaller pilot projects in other underserved counties. It would be great if we were everywhere, but we don't have unlimited people and resources, but I think that's kind of the ultimate dream. So also, thank you for Nadine Seebeck coming and giving her time to us this morning. Nadine's primary practice is representing landlords and housing providers.
That's all
Is
I
that
do.
it?
That's all I
That's
do.
all she does.
All I do.
And we think it's really valuable to hear from the perspective of Legal Services Vermont, where we're only representing tenants, but also hear from Landlords Council, and also to show you that this, while it is an adversarial relationship, is a functional relationship. We get along, we can work together, and while we're representing different clients with different perspectives and goals, ultimately the clinic, I think, has helped a lot of those cases come to a resolution where everyone is at least getting something of what they would like.
So, for example, we just signed a dismissal this morning.
That's right.
because
Yeah, we did.
The tenant got her tax refund, and that's down in Addison County, so that's,
Right.
the dismissal's going out today. So.
Exactly. We're still working, even during the training. So just a brief outline of how this morning will go. Nadine and I are going to be doing sort of the bulk of the training. We're going to do that until about 11. I'll try to be sensitive of the time and not go much beyond that. We'll take a short break at 11, and then from 11-ish after the break until noon, we'll be hearing from Sam Lednicki, who is a volunteer who comes to a lot of the clinics in Chittenden County. We think it's really valuable to hear from the perspective of someone who's actually come to the clinic as a volunteer and served in that capacity. We'll do a brief lawyer-tenant role play so you can kind of get a sense of what those client meetings are like. And then I think if you have really pressing questions during the first 2 hours, you can ask them. But I think that last hour will be a great time for us to give some answers. Okay, so for clinic introduction, as I said, they're in 4 counties, and the way that the clinics work, right, and the judge discussed this a little bit, is that you can file limited appearances. You are not on the hook for the whole case. The training binder that everyone should have a copy of, I provide a copy of all of the forms. You do not need those forms. But we provide limited appearance forms, so a notice of limited appearance and a motion for leave to withdraw. So those are all available. You are in for that one hearing and you withdraw at the end of it. So the lawyer is not on the hook for the case going forward unless, of course, you want to be. Generally, all of the folks that come through the clinic fill out an intake sheet. So the judge mentioned that if you want to keep the case, you can. But if you don't, generally there is follow-up with every person that encounters legal help at the clinic, and we contact them afterwards and offer help with the answer. But if you can certainly remind your client to check in with us on that, that's great. As the judge mentioned, this program, the goal is to sort of try to even the playing field between tenants and landlords. Overwhelmingly, landlords are represented, and overwhelmingly, tenants are generally not. And I like to think, and maybe Nadine, I hope, agrees, that sometimes having a lawyer on both sides makes the process a little bit more efficient. You know, a lot of the times pro se folks don't know anything about the process. This might be their first time ever in court. People are nervous, and there's a lot riding on it. And sometimes it's a little bit easier to deal with a lawyer on the other side rather than, you know, Nadine having to explain landlord-tenant law, no, I don't represent you, and going through all of that with a tenant.
And just on that, I think it helps me as the landlord's lawyer to have counsel on the other side, because then they trust the lawyer that they're talking with versus not trusting me. So even though, you know, like David will tell them, trust Nadine, she's not going to steer you wrong or whatever, it's the trust factor that really comes into play. So it helps, it really does help in that regard.
I agree. So, and just so everyone, I thought a statistic would be useful. The clinics helped approximately 187 tenants statewide in 2018. And because of weirdness with funding codes, that number actually only includes the expansion counties. It doesn't include Chittenden County, so the number is actually much higher. It's well over 200 people. So, you know, that's not reflective of everyone who has a hearing. Unfortunately, there are still a fair number of folks who default and don't come to their rent escrow hearing, but that is over 200 people who otherwise would not have had any legal help. So the program is making a difference. There is also the contact information for me and Angel Court for signing up, information, questions about the clinics. Please feel free to reach out to us. So you might be wondering what happens when I volunteer. First, I say first show up, but first is actually get trained. So you're here and you will be trained at the end of this. So you'll either be trained in person. This is also is being filmed and will be available on YouTube. You can be trained remotely. And get yourself a training binder. A training binder is, I made this sort of thinking, what's everything I would want to know if I were doing a rent escrow hearing. So if you don't bring it with you, someone on the legal aid or law line staff I'm going to say law online too, probably forever, will have a copy of this binder, and it's very useful for quick references to the rule. I sort of selected a bunch of unpublished cases that we sometimes rely on if we're making a motion to dismiss or some sort of other argument. So that's all available for you, and also the forms are there.
And
So-
it's come a long way, because when the
Yeah.
clinic started, there was no binder, there were no forms, and Maggie and her staff has done an amazing job by having this.
The grant really allowed us to do that, which is
Right.
awesome. So the first thing you do is you sign up and then show up. In Chittenden County, you sign up through court staff, and all the other counties, volunteers sign up through me. So you come to court a little bit early. Generally, most of the courts are block scheduling these hearings now. So it's for the morning or an afternoon. So it's not a full day commitment. It's usually
Burlington's always morning.
Burlington's. I think
Burlington's
the
always
only
morning,
Addison's the
right?
only place that does afternoon.
Addison afternoon,
Yep.
Burlington morning.
And so as folks start to show up, usually the people that look lost and confused are probably defendants. But our staff is generally trying to check in with folks, identify who those defendants are, and also ascertain if they would like legal help that day. If they do, we have them fill out an intake sheet. That's also in the forms. You don't need to do that. We take care of that. And we get all of their information so we can follow up later. During that time, that's a great time for you, the attorney, to view the court file and start to get a sense of what's going on in that case. In Chittenden and Rutland County, we get the court files that day. In the other counties, the clerks actually provide them to me ahead of time. That's really helpful because I get to review them ahead of time and issue spot a day or two before, and we've got our own hard copy available. Then, of course, next is meeting with your client. And I don't think I need to say this, but of course, when meeting with your client, the first thing you want to do is listen to your client and find out what it is that they want. Sometimes I think it's very tempting when you view the file and you find a really juicy motion to dismiss argument that you can make. It's very tempting to want to jump in feet first with that. But when I say listen to your client, it could be that you can say, like, I got this motion to dismiss, I can get this case tossed, we're good, and the person says, I actually moved out yesterday. So save yourself the time, listen to what it is that they want. I think Sam is going to get into this later, but listening to your client also needs to sort of come with, you structure that time to find out what it is you need. We don't have unlimited time in the mornings. The judge is very flexible. But, it's a clinic program, so you're meeting your client, you're handling a case in the same day. The other thing that, while the court might be flexible with us, we also try to be sensitive to the fact that, landlords are there with their lawyer that they are paying. So, the longer the landlord is sitting around and wait, that does run up the bill for the landlord, which, that might not necessarily be ultimately the tenant's responsibility, but we want to be sensitive to not just spend an unreasonable amount of time meeting with someone. I am thinking about that.
Oh, thank God, I know you do. But Tuesdays here, especially in Chittenden, are crazy days. I mean, Michael, you schedule, it's a crazy schedule, and it's hopping here, especially if the tenants show up, and sometimes they all show up, and we have to open up the upstairs for conference rooms, and it is crazy. So there's a lot going on here on the block scheduling days for landlord-tenant.
So once you meet with your client, identify their goals, then that's sort of the time that you can meet with the plaintiff or plaintiff's counsel, either say, this is the agreement that we want to try to work out, let them know you're going to bring a motion to dismiss, see what's going on in the landlord's end, and then a couple of things could ultimately happen. You can make your argument to dismiss the case. You could be presenting the judge or the court with some sort of stipulation. Rarely, but sometimes you might have a contested hearing. And then after that hearing, the volunteer attorney withdraws from the case. You have no continuing obligation on the matter. And our staff will follow up with the client afterwards. I'm not going to get too much into this slide because the judge talked about conflicts and what happens with the client after the hearing. So we provided the rule for conflicts. I think we're starting to change our thinking about conflict checks if we get the file ahead of time, but that means Legal Services Vermont is going to be doing a conflict check because we get the file in advance. But Generally for volunteers, we have some sort of list of all the cases scheduled for the day. And if you as a volunteer could just take a quick look at it, if you see a name you recognize, if you know that there's a conflict for you, just let us know and we won't give you that case. It's quite simple. And after the clinic, Legal Services Vermont attorneys will follow up, make referrals, help folks file pro se answers or counterclaims when necessary. So this is sort of just a brief list of topics that we're going to go through on the training today. And also just a brief note about sort of the importance of this clinic. The judge really talked about what she sees as sort of an imbalance in terms of who's represented and who is not in court. But, you know, the reality for a lot of the tenants is that affordable housing is a very difficult thing to find in Vermont. I have provided some statistics that you can look at just ahead of the PowerPoint. There's I think it's the National Low Income, what's it called? Homeless Coalition? I don't remember. But there's a great organization that puts out how much folks in each state have to earn an hour in order to afford a 2-bedroom apartment in their state. In Vermont, that's $22.40 an hour that you need to earn in a 40-hour work week to afford a 2-bedroom apartment. I can tell you that all of my clients do not make that kind of money and are either, you know, just paying way more than I've seen folks paying 50, 60, 70% of their income towards housing.
And they're supposed to be paying 30% according
Right.
to the government.
Right. HUD has deemed that that's affordable. Only folks getting housing through HUD, I think, are actually paying
Right.
30% of their income for housing. So there's a lot of barriers that tenants face, and you know, if this program can help people either avoid homelessness, avoid some of those consequences, or at least if we can't avoid that, at least give people enough of a heads up and time to plan to at least mitigate those awful side effects of homelessness, that's our goal. Okay, I will hand this over to you.
Law, right to the law. All right. So, how many have you done any landlord-tenant law? I know Amber. Okay, good. Some people, excellent. It's a very interesting area of the law, and I love it because, and this is all I do. I cover the whole state, and I'm like killing Maggie with my pen. I just happened to get into this with the firm I was in and then went out on my own back in 1995, and it just blew from there. I cover the state, and like Maggie says, you see a lot in this particular area of the law, and it's fixated in basically 3 titles, 9, 10, and 12. I love it because it's pretty, for the most part, short resolution. You do get to court, you get to interact with other attorneys, you interact with people, and I tell clients a lot, or not clients, but you know, if I'm talking with legal aid, I feel like a social worker most of the time. Because if someone is to lose their housing, especially if they have a subsidy and they have 5 kids, where are they going to go? I mean, it's just that the burdens on the system are already overwhelming, but to lose your housing is just catastrophic for a lot of people. And the judge mentioned the evicted book. I just read that because I taught a class at St. Mike's a few weeks ago. He's spot on. Legally, the process might be a little different from state to state, but Matthew Desmond is spot on. So it's a really good read, and I encourage you to read that as well. So the 3 titles, again, are 9, which is for apartments. Title 10 is for mobile homes, and I think we're not going to talk too much about mobile homes today. And if you do get a mobile home situation, and by mobile homes I mean there's a mobile home park, and then the tenant rents the lot within the park, and they own their own home on the lot. So that will take you outside of Title 9, and that will bring you into Title 10, which is a whole different set of laws, notices, things like that. The other laws that apply are Consumer Protection Act, which is under Title 9. Habitability is, I'd say, one of the biggest offenses that I see. I have a leak in my roof, my toilet doesn't work, I don't have sufficient heat, things like that. And there are certain steps that the tenant has to take in order to avail themselves of that particular section of the law. There's all sorts of Vermont Department of Health, We have fire marshals all over the state. We have town and city municipalities that also do inspections and things like that. And usually I find by the time, if it gets to court, there's usually some sort of report from the municipality as far as habitability. But the habitability could be raised at the court when you get here. It may not be a defense if proper notice was not given to the landlord, but you could send them to various agencies to have at least the unit inspected if there are habitability issues. And A&R, yeah, wastewater and water rules are very important. EPA, the lead paint, I really don't get too many of the lead paint cases, but I did actually just wrap one up with Sam Lednicki, who's going to be here later. And you have to do essential maintenance practices and things like that. Lead cases really aren't as prevalent because landlords are really required under the Department of Health to maintain their units. If they don't, then they could face some serious fines. So I don't see it come up too much. The other hot button issue, I think, two things maybe are mold. That's kind of subsided over the last few years, but mold is an interesting issue because tenants think anything in their apartment that looks like mold is hazardous mold. And I think most of us have had like a fan that doesn't work really well in your apartment and you start getting either black on your ceiling or wherever. That is not, that's not your legitimate.
That's not the stuff that's going to cause the major
It's
health
not gonna
problems.
kill you.
Right.
So mold is big. Bed bugs are really big right now. Things like that. So you never know what you're going to hear. And then Agency of Agriculture, Maggie's got pesticide regulations, but
This is mostly just so you have the sites, but
Right.
we don't see this come up a lot. A lot of
Yes.
the,
And that's where it comes to listening to your client, the tenant, to see what their issues are, because you'll be able to gauge whether it's a legitimate claim or whether they're, some things are just minor and it's not going to rise to the level. So I'm going to put Amber on the spot because really I don't see, and I'm here pretty much every escrow hearing, and and so are you. You're here all the time. So, and like Maggie was saying, there really aren't too many contested hearings, and I really don't see a lot of contested hearings. I work most of mine out. However, Amber did have a contested hearing this week representing a tenant, and she prevailed because the rent was, $1,000 a month, and Judge Tour awarded $300 a month based on, I think he didn't have a stove and some other issues, and she had to put the tenant on the stand, the landlord testified, so you do get experience, a lot of experience, whether it's just client interaction or appearing before the court, and Judge Tour usually makes her decisions right at the hearing, so there's no written findings or anything after that, so you'll know right then and there where your client stands in the case. So I thought that was great. It was very good, and the courtroom's packed. Okay, so
I'm glad I didn't know that, because just for the record, that was like my first time.
Oh, was it
Yeah,
contested?
I
Oh, okay.
graduated from law school like 15 years ago, and I haven't done, I haven't seen evidence rules and all that stuff in 15 years, and that
Yeah.
scared the crap out of me. But I made it through.
well, that's
so.
great that the clinic got you experience doing that.
And that was one of
yeah.
my reasons for doing the clinic, was it gets you time in front of the judge, it gets you the experience, and now I can, I do represent landlords occasionally, as Nadine and I have the occasion to chat outside of here, but it does get you that, and it made me feel comfortable for my hearing yesterday, in which I represented the landlord. Yeah. Yeah.
Good, very good. All right, special situations. So there's all different types of housing. There's market rate housing, there's subsidized housing. The subsidized world is all over the place. It could be anything from a tenant has a portable Section 8 voucher, which means the tenant can take the voucher wherever they want. And that's all through HUD. There's also housing with Section 8 project-based, where the subsidy, and again, when I say subsidy, it's usually based primarily on the tenant's income and household size. And Section 8 based is where the subsidy is with the unit. So in a case where a tenant gets evicted from a subsidized based unit, they lose it. It's gone. They'll never, we talk about that. If you lose your subsidy, the chances of getting it back are really not great. Even if you did pay your debt to your landlord, you get back on a list, and you're on I think it's at least 7 years. Burlington Housing is 7
I've
to
heard
10.
7 to 10 years.
7 to 10 years before you'd even come up on a list again. So losing a subsidy is significant in this state. There's also rural development. We have low-income housing tax credit. We have home units. We have HODAG units. We have, and I do a lot of, vast majority of my clients are subsidized and affordable housing, but I also cover private landlords as well. Community development block grants. I mean, there's all sorts of mental health vouchers through the state. There's the Vermont Rental Housing Subsidy Program. There's a lot of subsidies out there, and they all have different rules and regulations. So that's why if you come and you have a tenant that has any sort of subsidy, like Maggie's here, David's here, somebody's here to help you steer you down the right path as far as the subsidy goes.
Yeah, the subsidy ones can be a little bit complicated, but I think, the main goal there is really to try to either preserve the subsidy or keep the client in the apartment where the subsidy is attached. But if you start to see, the reason why all of this is in here, you don't have to become an expert in these subsidy programs, but just sort of have a vague awareness of these names. So if you see any of them, to let us know and we can help you. It also flags for us, there are certain type of subsidy programs where if you're being terminated from them, those are priorities for Legal Services and for Vermont Legal Aid. Maybe that's a client that we refer internally for full representation, just because losing that subsidy is such a critical thing. And again, if you see a mobile home park case, there are very different rules in Title 10 from Title 9 regarding terminating the tenancy and the lease. So if you see that, let us know and we can help you with it.
I was just going to say, so if you're here for rent escrow day, it's only basically non-payment. Non-payment is your issue of the day. There's also other types of evictions for cause, drug activity, noise violations, things like that, but you are here basically on non-payment issues. All right, the basics of landlord-tenant law. The tenant has, under Title IX, the statute, the big responsibilities for the tenant are that they comply with the terms of the lease, they don't violate any health or safety laws, which there's plenty of those out there, and they also, the other biggie is quiet enjoyment, that they don't bother their neighbors or create unreasonable noise. Let's see, what else you got in here, Maggie? So with a lease,
I think you're on.
am I on the right one? Basics of landlord-tenant law.
Yeah, you are.
I am.
You are.
Phew, okay. So a person under the landlord-tenant law is, your lease can be oral or in writing, and I'll mention that, I know it's in the book, but a few years ago, the law changed as far as written leases now must be attached to the complaint when the complaint is filed by the landlord. If it's not, it's grounds for dismissal. So read the complaint, see if it's an oral or a written lease, and then see if the lease is actually attached. And then the sheriff's return of service will signify what's been served and if there's attachments as well. Tenant retains possession of the unit until one of three things happen. Basically, they give notice that they're going to leave, the landlord evicts them, or in a lot of cases, the tenants just leave without notice, which drives me crazy. But, most of us would give notice and be responsible, but a lot of people just pack up and go. And the biggie is landlords cannot use self-help evictions. Those are illegal, and I don't see that too much. Every now and then I'll get a referral from legal aid because that drives me crazy if a landlord basically throws the tenant out, cuts off utility services, cuts off the heat, things like that, and I'll step in and represent the tenant because the rules are the rules, and landlords have responsibilities and tenants have responsibilities.
Represent the tenant?
Every now and then, yeah. Every
That
now
is
and then.
good to
Yeah. Oh, now I'm in big trouble. Now I'm in trouble.
So now you have tenant obligations.
Can I just say something?
Yes.
Just because you guys didn't mention it, I thought it might be good for you all to know that the average value over the life of the years that someone has a subsidy is about $250,000. So you have to think family making is somewhere between $15,000 a year over 10 or 15 years, having a $250,000 rent shot, so to speak.
So just a brief reminder, I don't know how well the video is going to pick up on unmiked people. So if there's questions or comments, I'll try to repeat them. But essentially what David was saying is that the value of it's just Section 8 subsidy or all subsidies?
Well, any subsidy.
Any subsidy over the lifetime of the
70%
subsidy?
of your rent for 10 to 15 years.
Right. So how much that subsidy is paying for the person's rent, I guess, on average is about $250,000. So that's how much of a financial benefit that tenant is getting. Have I gotten that? Right.
How much of a hit they're gonna take if they lose it.
Right. It's a huge loss.
And we all know how expensive market rate apartments are and how hard it is to find, so. Are we on basics?
Tenant obligations.
What else, Maggie? Oh, basics of landlord-tenant law. So I talked a little bit about it. Tenants have to pay their rent basically by the 1st of the month. Some landlords give you an extension to the 5th or the 10th. If they don't pay after that, under the law, the landlord can send the notice out right away. Prior versions of the law, you had to wait till the next month, but now if the tenant hasn't paid it by the deadline, you can send a notice to vacate out, which triggers the case to start. And then, again, not disturb the neighbors, not damage, that's another biggie. Nope, don't cause damage to the property. Tenants also can't deny landlords access to the unit as long as the landlords give at least 48 hours notice, unless it's an emergency, fire. It does happen. I get calls all the time about getting into the unit in case of emergency. The tenants also have to comply with the other terms of the lease. Now with the whole cannabis law and smoking and things like that, that all has to be in the lease. Otherwise, it's not enforceable. And then vacate the unit upon lawful termination of the tenancy.
And tenants in Vermont, of course, have rights that need to be respected. The tenants have a right to be free from discrimination. We provided all the sites to the rules here to have the landlord make repairs to defective conditions within a reasonable period of time. I put that in there. One of the things that comes up pretty frequently in the clinic is that someone does have a defective condition, something that really needs attention, and our question will be, okay, have you told the landlord? And sometimes the answer is no. A landlord is not going to know if we haven't told them what the problem is, so we'll get into how to provide that sort of notice later, but that does actually have to be communicated so the landlord can do something about it. The tenant has the right to be free from retaliation if they complain about those defective conditions, to have exclusive use and possession of the rental unit. That means the landlord can't move in themselves or a family member, which we have seen before. And to be treated with good faith and fair dealing by the landlord. This is you.
Yes.
Steps in an eviction case.
So the steps in an eviction case, and it's the same process. It's a very procedural type area of the law. I mentioned briefly earlier, notice to vacate. So in the complaint package, you'll see a notice to vacate. That has to go out. It has to comply with the law. For a non-payment case, the landlord has to give at least 14 days plus mailing time. So under the law, there's a 3-day presumption that the mail will be received. So you have to make sure when you check the notices, when you're checking the court file, that the landlord is given proper notice. And I still see every now and then, not me, but if I'm here on rent escrow day, lawyers will put in, and lawyers, not just the pro se landlords as well, but not put an actual termination date in the notice, and they'll just put 14 days from the date of this notice or something like that. I know Judge Tour has ruled that it has to be a specific date. That did come up a few years ago, I think, in a contested escrow hearing, that the landlord just put a generic 14 days from the date of the notice, or 14 days from receipt of the notice, I think it was. If you don't have a specific date, the notice can get tossed. If you don't put the right amount of rent in, the case can get tossed. An issue that's come up in the last couple years, our landlords are including in the notice to vacate for non-payment of rent, late charges, utility bills, water bills, things like that. It's only rent. So when you check the file, you want to make sure that it's only rent that is listed in the notice to vacate, because if it's anything other than that, it's grounds for dismissal. The other biggies, you want to make sure that the tenant's address is correct, that they may say they never received the notice, which comes up a lot, but if it's sent to their actual address, then it's deemed received. Other issues that come up, some landlords will just hand deliver their notices. And so under the law, it says actual notice. So actual notice can be hand-delivered or by first-class mail. I send my notices multiple ways, just so we don't get any issues, but if a pro se landlord sends out their notice and they don't, say they hand-deliver it, and you ask, well, how was it hand-delivered? If they say it was put on the door, and the tenant says they didn't get it, guess what? The case is gone, so you have to put it in hand. If it's sent multiple ways, it's sent first-class mail and certified and hand delivery, then your chances of that notice getting to us are slim to none. Those are the, I think those are the biggies.
We'll get more into notices later too,
Are we?
but yeah.
Okay. But that's the biggie with the notice. Once the termination date comes, so a landlord can't do anything until there's actual termination of tenancy. Once that happens, if the tenant has not paid, the way the law works is it's whatever you owe as of the date of the notice, and I always include in my notices, plus any rent that comes due, because a lot of times you cross over into the next month. If the tenant doesn't cure everything as of the date of payment, then you can proceed. So for example, if you send a notice out in March, the beginning of March, and say the tenant owed $1,000, and the termination date was not until April. If by the end of March, the tenant paid the full amount that was in the notice, the case is over, they've redeemed the tenancy. If they cross over and they only pay the amount that was in the notice, and now they owe another month's rent, it's still a good notice. So if the tenancy terminates, then what happens is we start with a summons and complaint. I serve a lot first. A lot of landlords, the judge was alluding to earlier, a lot of landlords or landlords' attorneys, they file the case automatically, they get an escrow hearing, and then they serve the summons and complaint with the escrow hearing. Escrow hearings have to, and here's another area, escrow hearing notices have to be served at least 14 days before the, right, 14 days? 14 days before the hearing. If you're short on time with service, the hearing can be rescheduled. So the statute's very specific on that. So I have the option as a landlord's attorney, I can either file the case first and get an escrow hearing, or I can just serve the tenant with a summons and complaint. I think I resolve a vast majority of my cases, because a lot of times the sheriff will tell the tenant to call me, and then we get it resolved before I have to file. Because keep in mind, under the law, the tenant has to pay the court costs in order to stop the case. Not the attorney's fees, but the court costs. The court costs are $295 for the court filing fee, and then the sheriff's fees, which if there's 2 people in a unit, you're looking at least $100. So the court costs on average are pushing about $500. So especially if you have a low-income person, to have to come up with the court cost is sometimes as much as the rent that's owed. So we try to figure it out. But anyways, moving on. So do a summons and complaint. If the case actually gets filed and there's a hearing, we show up here for escrow day. For my cases, if the tenant files an answer, then I file for the escrow hearing, and then we get to court. Sometimes I do get motions to dismiss, not too often, but I don't think, are you putting motion to dismiss in the context of doing it at the escrow hearing?
Doing it at the yeah.
Okay.
Because, if we're at the rent escrow hearing
Right.
and you see that there's a motion to dismiss ground, if there is a way to dismiss the case, the judge will have to hear that first before they can order rent into court. So that's why it's there.
Okay.
Yeah.
But they do come up, I find not, I really don't get many challenges, but there are a lot of defective notices that if you read
You don't
them-
get many challenges.
I don't get any
Other people
challenges.
do.
Yeah, so if, you'll know the minute you look at the notice, whether it's in compliance with the law or not. Some things are really, really glaring. So then, sometimes the tenant will file an answer before you get to the rent escrow hearing. If they have, then the tenant won't need any help after the escrow hearing. So once an escrow order is entered, either we agree on the date for the answer to be filed, or it's 10 days, right? 10 days, most of my file answers. I think it's 10 days,
Yeah.
14 days
Right. I
from
think
the
that, yeah, because of the
escrow.
rule change, yeah.
Yeah, those darn date
I know.
changes. So 14 days from the escrow hearing to file their answer. The answers are important. For me, as the landlord lawyer, if the tenant shows up for the escrow hearing, I'm not going to default, but don't trust don't trust the other lawyers. If a tenant shows up for an escrow hearing, I'm never going to default them unless they move out, and then if they haven't filed an answer, then I'll default them. But if they're in the case and they're paying their rent to court, I'm not going to default them. But you want to make sure that you give them advice to how they get an answer filed with the court, and then Maggie and Legal Services will help. Are the forms in here for the answers?
The forms are not in there for the answers, but sometimes we have them at court. I know some of our pilot programs are talking about just doing an answer right there so it's done. But with the follow-up, we do answers. So.
But there's all sorts of forms out there, circle this, add that, which make it pretty straightforward. And then usually if you appear before Judge Tour, she always wants to know what the next steps are. So when you're talking with your client, you want to kind of, it's a combination deal. Between talking with your client, the landlord's attorney, you'll know where things are going, and then I usually take the lead on what's going to happen next, either if we need a status conference or I'm requesting a final hearing. You never know. We just kind of, they're all a case by case, because I've been doing this for 25 years and I still get situations that I would never expect. I thought I'd seen it all, but something else always comes up. It's never boring. We do have you can have a bench trial, or you can request a jury trial in a landlord-tenant case. I never request a jury trial. However, the tenants sometimes do. And I have a jury draw in a couple weeks, and I have a trial in May. It's an interesting case.
That'll be fun.
I didn't ask for it. She's moved out. It's a non-payment case, but she's raised habitability issues. So that's a long story. I can fill you in after this for the details, the sordid details. Then we get to the end of the case, and what the landlord is looking for, if you can't work it out, is a writ of possession, and the writ is what gives you the right to take back the apartment. It's served by the sheriff, enforced by the sheriff, and once the writ is issued, if it's through a judgment, it's a 14-day writ, and basically the sheriff serves it and tells the tenant when he's coming back, and if the tenant is not out, then the sheriff will enforce and execute the writ. So those are always a good time when they're still there, but for the most part, that is the process in a nutshell.
So I'm realizing my rent into court slides are up a little bit ahead, but some of you indicated that you'd never done landlord-tenant law, or maybe had never been to a rent escrow hearing. So now might be a good time to super briefly just say, like, what's rent escrow? And we're an hour in. So
Yeah, that's a good
thing.
point.
Yeah. So I will just say what that is briefly. We will get into a little bit more detail later, but rent escrow, landlords can ask for a rent escrow hearing, which is just a portion of an eviction case. A landlord can make a separate motion to the court for the judge to make. Whenever I explain it to my tenants, I say the judge is just looking today for, does someone owe rent? Does the tenant owe rent? If the answer is yes, then the judge is looking at, am I going to be entering some sort of order for the tenant to start paying their rent to the court clerk in this case? That order will have how much money, when those payments are due, some sort of schedule. And the reason why these clinics are here is because it's a great time. The parties are all together, right? So it's a time where we can work out what rent escrow is going to look like. It's also an opportunity to sometimes come up with a more global resolution of the case. Either some sort of move-out agreement, a repayment agreement, something that either helps both parties, recover from this and maintain their relationship, or go their separate ways. So there's an opportunity for that as well. But that's why this is an opportunity for the parties to come together, and it's a great opportunity for legal intervention. The reason why rent escrow is so critical is because if a tenant is ordered to pay rent into court and they miss that rent payment, the landlord can come back to court and say, my tenant missed the payment, and now I want a writ of possession. And if there's no sort of excuse, nothing's worked out, that landlord will get the writ of possession, and the tenant can be moved out of their apartment by court order within 5 days of getting served that writ.
It's a shorter writ. It's a shorter writ for rent escrow.
Yeah. So that's why this is so critical. We want folks to make sure that if that order enters against you and you don't comply with it, the consequence is being dispossessed from your apartment even before there's a hearing on the merits, before the judge hears your side of the story. That's why this is such a critical program and why legal intervention is offered at this point. So I just want to say that for folks that might not be sure about what rent escrow is. We will get into a little bit more detail about that, but just for the background, that's what happens.
So with the rent on a rent escrow, because you have to explain that, you have to explain the order to your client, and you have to explain what happens if they don't pay.
Right.
And I get that all the time from the tenants, what happens if I don't make the payment? And sometimes they're just not going to be able to make the payment, and you know that.
Right.
So they want to know, when do I have to be out? What's the time? And the realistic view is, so whatever you agree on the rent escrow, if they don't make it by that date, then usually, for me anyways, the paperwork is up at the court the next day. Judge Tour is extremely fast. Not all counties are that fast. She is lightning speed. And Michael will attest to that. And she issues orders very quickly. Once I get the writ, it goes to the sheriff. Once the tenant gets served, it's 5 working days from there. So what I tell tenants is, on average, from the time you were supposed to make the payment to the court, you've got about 2 weeks.
I tell people like 5 to 10 days.
Do you really?
Yeah,
Wow.
just to be prepared, because any extra
Right.
time is bonus at that point.
Right.
But yeah,
Right.
it depends on the county, though. You're right.
Right, at least 2 weeks, and that way they know they can prepare, they know, no one wants to be there when the sheriff comes, and a lot of times they're out, but at least they know how much time they have, and that's a lot of times what they're looking for is, how much time do I really have to be out?
So when you come to the rent escrow clinic and meet with your client, as we discussed earlier, identifying the client goals and having that interview with them are the first things that happen. A lot of times your client, you'll see this in the role play later on, your client might want to talk about, here's everything that's going on, here's why my landlord's a terrible person, we don't get along, and they might want to get into all that stuff, which is very important to that person, right? It's their life, this is what they're dealing with, this is their home, and those things matter greatly to them. But those things are not necessarily relevant at the rent escrow hearing. So a lot of the times, and what you'll see demonstrated later on, is that you as the attorney need to know a couple of really key things. And one of the first questions I kind of ask is, do you want to stay in this apartment? And sometimes if a client's going on to me about how terrible their landlord is, I might say, this sounds like a relationship that maybe you don't want to continue, or you don't trust each other anymore, maybe. And that might be the first time it's occurred to them, like, oh yeah, I guess I could leave. And maybe that's what we want to start working towards, getting that person out of their apartment, having the parties go their separate ways. But that's really something you want to know. What am I doing here as the lawyer? Am I trying to keep you in here, or am I trying to facilitate something where you can vacate? It's also important to know about habitability issues, but I sort of put in the caveat, are they ready to be raised today? If your client is telling you, yeah, there's all these problems with my apartment, but I have told no one about it before today, in my opinion, that's not necessarily ready to be raised that day, unless it's something sort of catastrophic, like I don't have heat, I have no working toilet facilities, the pipes have burst, something really major like that. But if it's something, perhaps, and again, I don't want to minimize any habitability issues. This is someone's home. It's where they live. If something's wrong with it, that is really troubling to someone. But I also try to put in the reality check of, if there's a leak under your sink and it's making the wood a little rotted in the cabinet, I wouldn't like that either. But does that make the apartment unsafe, or does it make it uninhabitable? Can you not spend the night there? No, you can. So when we ask about other habitability issues that are ready to be raised today, have you brought it up with the landlord? Has it been brought up with the town health officer? What kind of proof are we working with? Those are important things to know. It's also important to know, does your client actually owe this rent, and are these amounts correct? Sometimes they're not, or sometimes your client will say, yeah, I owe something, but it's not this. Or they've made a payment since the complaint was filed, so the rent escrow order might not be all that the landlord's asking for. That might be a smaller amount. The other questions are, can the client afford this apartment? Sometimes I'll have folks tell me, yeah, I really want to stay, but the rent is $650, and their income is SSI, which is roughly $800 a month. So I might look at that situation and talk to the person about, is this actually it might be that there are no other options, right? But is this actually affordable? Is this something that if we get you back on track, are you going to be able to sustain this going forward? And, you know, whether or not the person can afford the rent escrow amount, and is a payment plan going to make any difference? Sometimes it's not possible, but sometimes it is. And, you know, we at the clinic and at Legal Services afterwards, there are a decent number of community organizations that will help with back rent. So we are frequently making referrals. Nadine is frequently making referrals to opposing parties in her cases for folks to get that money together so they can keep their housing.
Do we still have the pamphlets? There used to be pamphlets on the table that had.
And there's, in the binder, I have for each county a resource page. So that includes town health officer for that county, although those folks change. So they're the most recent for now, but I think their appointment periods are like 2 years, 3 years, it depends. So it might be a different person. So once you kind of know what your client ultimately would like to have happen, then it's a time to go talk to the landlord or opposing counsel, see what the landlord's looking to get, negotiate. And, you know, the contested hearings, I think, are really mostly about if you're raising a motion to dismiss or if you're raising habitability issues. I also wanted to put in what I started referring to as the two defendant problem, which brings up sort of unique clinic issues. So sometimes we'll get the calendar sheet and there are going to be two defendants listed. Until folks come to court, I don't know if those people are adverse, and sometimes they are adverse. I don't know if both of them are coming to court, and you have to deal with that, you know, the day that you're meeting with your client. And again, clinic staff have seen this before, so we're happy to help you. But I've had that situation where one defendant shows up or both have shown up and they're adverse, like they just got divorced, or they are, you know, for whatever reason, or roommates who are blaming each other for not paying the rent. So those folks are adverse. The clinic can only represent one of them, but sometimes we'll have, you know, a clinic staff person represent, or maybe just give advice to both, but then we don't talk to each other about the case. A volunteer will give advice to one, and we might do that. That's happened, I think, once, and it's easier to do that if the one person's over the phone, because that does happen too, where one defendant will be there and say, yeah, my girlfriend's sick, she couldn't come. But what happens if you're trying to get a writ that day? Girlfriend is not there to accept service. The way I handle that, if there's a court order that applies to both defendants that are in agreement but one is not there, is generally I might try to get that defendant on the phone in the courtroom, have the court clerk call them, get that person on the phone for the hearing, and have that person say over the phone that they consent to their co-defendant accepting service of a rent escrow order. But really, I think where that comes into play is if there's a writ. I think everyone really wants to hear that I'm okay with my co-defendant accepting service of this writ so that there's no question later. But if you have two defendants and you're not clear about the relationship, or you want to talk it out with us, just bring it to clinic staff and we can help you with that.
And then we have the contents of the file. So don't worry, it's not like it's this thick, right? It's pretty quick.
It's not a binder.
It's not a binder. The initial pleadings are very thin. You get the notice to quit, also called a notice to vacate, the summons, the complaint, the lease, the return of service from the sheriff, and then the motion to pay rent into court, those pleadings. Usually the motion, it has to have an affidavit with it. You might see a proposed order, a proposed hearing notice, and then the actual hearing notice that went out. And the key is you have to look at to make sure that proper service is there. So you look at the return of service. If the escrow is filed, when the case is filed, the sheriff will check off notice of hearing, so you know it's been served, check the service date. If the tenant, so for example, if I don't file the motion until after the tenant files an answer, then the tenant has appeared in the case, and the court can mail the notice of hearing to the tenant. So I don't need service if the case has been filed and an answer's been filed by the tenant. So you might see some of that as well.
Okay, notice to quit. The slide is brief on this, but at the end of the PowerPoint presentation, Sam Lindnicki, who's a volunteer in Burlington, graciously let us use her handout and cheat sheet for notices to quit. So it kind of goes through a little bit more detail about the rules. and gives this really fantastic chart, because notices to quit, depending on what they're for and what type of tenancy and if is there a lease, there's all these different amounts of time that are required in notices to quit. So the chart really helps you quickly ascertain, is the right amount of notice given or is it not? But this is where I start when I look at court files, because what you have to know is, was this tenancy properly terminated? The notice to quit, which I explained to tenants, is, the landlord's first step in a case. You have to tell your tenant, I'm ending this relationship with you. Here's why. I mean, if it's non-payment or for cause, here's why. Or if it's for no cause, they can say it's for no cause or not provide a reason. They have to say, I am terminating the tenancy effective this date. As Nadine said earlier, saying the date is important. There are some of the unpublished cases talk about how it's not up to the tenant to count the number of days. The landlord actually has to say what date the tenancy is terminated. And then if the tenant stays longer than that, then they file their case. But that notice has to comply with the law. The tenancy has to be properly terminated before the case can be heard by the court. The judge doesn't have jurisdiction over the case unless the tenancy has been terminated ahead of time. So we're looking for in that notice, was enough time given? If it was mailed, were the 3 days for mailing provided? And was the actual date specified? Were there amounts included other than rent? I've gotten a couple really good decisions lately from other courts about late fees being included in rent. It ended up beyond rent escrow, unfortunately, in a motion to dismiss in a case that I kept. I just had a landlord, our motions back and forth clarified nothing. I wasn't really sure how he was, doing his math or what he was adding in, but then he helped me a lot at the hearing when he said, well, they might be calling this gas charges, but I call it rent. And I thought, yay, you've done my job for me. So he identified for the judge, yeah, I included charges that were not rent, and that, gave the judge what he needed to say, okay, if you've included other charges other than rent, I'm going to dismiss the case. The reason why that's important is that if the tenant needs to be notified, here's how much rent you owe. If you pay this amount of rent to me before the date in this notice is up, I will stop the case, or it won't proceed to a summons and complaint. Some judges don't think that, and that's the redemption clause, some judges don't think a redemption clause is necessarily required. It's our position that it is, but you might have a judge that doesn't see it that way. My view, though, is that if there is a redemption clause, if you're going to use it and then it's misleading in some way because it does include those other charges, I think that is enough to get a case dismissed, but it's an argument that's definitely worth making. If a notice is for cause, again, this is for rent escrow, so rent escrow is just about non-payment. It's about money being ordered into the court, but sometimes you'll see a for cause notice where the landlord is alleging some sort of violation of the lease. Criminal activity, you moved in someone without my permission, you have a dog that I did not agree that you could have, and that cause, that rule violation, does have to be specifically described in the notice. I always think of my colleague Jessica always has a story where the landlord said that the tenant was being goofy, and I don't know what that means. That's not, I know. That's not specifying.
I did not write that letter.
No, that was not you writing that. But we're not specifically describing the activity, right? The tenant has no way of knowing what that means, and they have no way of potentially remedying that problem because goofy is subjective. Maybe that's a good thing. And for no cause, again, please see the chart for timing. The no cause notices are different amounts of time based on whether or not there's a written or a lease. Has the tenancy lasted 2 years? Has it lasted longer than that? So because those timelines are so different, just check the handout and check with us. But and it's also different if you're in Burlington.
Yes.
The Burlington ordinances actually give a little bit more time. So that's an important thing to look at first.
And you may see this in a rent escrow because there might be a 2-count complaint for non-payment and cause. Even if a landlord brings a cause case only, you can ask for rent escrow if the rent is not being paid. So these issues could come up for you for no cause or cause notice as well.
And of course, if the notice is defective, then that leads us to motions to dismiss, or as my colleague mentioned in this PowerPoint, making the case go away.
However,
Sometimes
it's going to come back.
that's true.
So
And
you have to factor that in
and we'll
as well.
talk about that because, sometimes it is very exciting to bring a motion to dismiss, but, if you get the case dismissed, your client owes money, what's the landlord going to do? They're going to refile, and you'll be back in a month or 2 months. Maybe that's what you want. Maybe your tenant's just looking for a little bit of time. That's the time that they need to move out. Maybe the landlord won't refile if that person's vacated, but it really only gets you time. I mean, just yesterday, I had a couple grounds for a motion to dismiss, and they were juicy. There was no redemption clause, a notice had been taped to the door, but, what my client wanted was to leave. My client ended up, she's going to be leaving in 2 weeks and the landlord's going to be paying her a little bit of money. That's what she wanted the most. So for, arguing the motion to dismiss in that case, it would have gotten her time, might not have gotten her out of a judgment. So it's important to sort of talk with your client, I could get this dismissed, but it will come back. What do you think about that? Maybe a global resolution to the case is really what you want to be doing. But if there are notice of problems, that is a 12B1 motion to dismiss. This is the part where your lawyers, know how to make this sort of argument, but we put the reference in here just in case this is a new area of law. I think it's always important if you're making a motion to dismiss, depending on the judge, I think it helps to sort of explain what the notice defect is, give them the rule that gives them the authority to dismiss the case, give them, sort of help them create the record. But a notice to quit problem would be a 12B1 argument. The notice, I think we talked about all of these issues. And there's sort of a special note for subsidized housing. There's unpublished cases about this. If there's a subsidized housing provider that's also a party to the lease, the landlord has to provide contemporaneous, notice to quit has to be contemporaneous to the tenant and the housing authority. How do we know that that happened? Sometimes the complaint will plead that that happened. Sometimes the notice will include a little CC at the bottom, CC Burlington Housing Authority. If that's not there, then I wonder whether or not the housing authority got it at the same time. Sometimes they still did. But if they didn't, that is a motion to dismiss because not all of the parties were notified of the lawsuit.
And that's only for portable vouchers.
Right. And, another, for 12B1 arguments, there's also standing issues. We do see this come up frequently when a corporation is the plaintiff. I did put into the rules section the rules on corporations being represented by a non-attorney representative. I've seen that happen a bunch of times. It tends to be sometimes the same folks over and over, not retaining counsel and maybe not doing the same pleadings correctly. But that's an important thing to look at. Sometimes also if you see that there's a corporation listed as the plaintiff and you look them up on the Secretary of State website, which we can do. I mean, everyone has a cell phone. We usually sometimes have a laptop at the clinic. We can look that up. If that corporation is not registered with Secretary of State or that registration has lapsed, that is a basis to dismiss the case as well. And also, plaintiffs trying to evict the tenant from the wrong address. That has come up.
Or, years ago, I had a client who moved someone without telling me. And then
That's not good.
They were rehabbing, and I get the writ, and the sheriff goes over, and he's like, "They're not there." I'm like, "What?" So, you never know what's going to happen with these things. I'm telling you. I was going to mention too with the subsidized housing notices. So there's the Section 8 sending notice to Section 8 to Housing Authority at the same time. But there's also, if you look in the lease under termination or default section of a subsidized lease, say it's project-based or rural development, you have to add extra language. You have to give the tenant the right to an informal hearing. You have to tell them they can defend themselves in court. And when Maggie talks about in the cause notices being specific, the subsidized housing notices are like off the chart specific, and Judge Tour has ruled on that. So the notices are a crucial part of what you're looking at.
Yeah, that's useful.
12B6. So again, you're all trying to make these cases go away. Not with me. Not with me. You don't fight with me too much.
That's true.
So during a lease, and this comes up sometimes, if you sign a lease for a year, Do you think you can leave anytime you want with, say, 60 days notice during the first year of the lease? I'm seeing yeses and nos. So if you sign a year lease, you are locked in for the year. That is the bargain that you made, that, depending on how the language is crafted in the lease, but usually if you sign a year lease or a year-to-year lease, that you are in during that time period. Sometimes we see notices come out like during the first year of lease, which I would never do because, but I'm sure you see it.
We do, yeah.
That a landlord is like, hey, I'm going to give you 60 days notice to leave for no reason. And no reason, there's usually a reason.
There's a reason.
Usually a reason.
There's a reason.
You can do no cause in Vermont, and I want to clarify for that. For subsidized housing, so if you see a no cause notice in a subsidized housing case where they don't have a voucher, see, it gets complicated because that's why Maggie and David are here. You can only evict for cause from, say, public housing or project-based housing. So we're very limited on that. But if it's within the year of the lease, then the landlord can't be sending you a 60-day notice, so you shouldn't even be in court because the year is the year. A lot of times leases will go a year and then month to month after that. If it's month to month, then either party can give notice, usually 30 or 60 days that they have to go.
I think a good way to think of it is the difference between non-renew and terminate. If it's a written lease, if it's a no clause, then really what you're doing is not renewing the lease. When do you
Right.
not renew the lease? When does that go into effect?
Right, so non-renewal is always interesting. But you just have to, it's very, and you'll see the chart. I haven't seen Sam's chart yet, but it sounds impressive.
It's great,
Because
yeah.
there's a lot of timing with these things. It's very methodical in this area of the law. Non-payment of rent is not owed. So sometimes there are cases where the tenant pays before you get to court, or the tenant brings cash to the courthouse. It does happen. If the tenant pays, then you just have a matter of the court costs, and then is the landlord, and this is something that you can ask the landlords, are you willing to waive the court costs? So my client is here with $2,000 in cash. Are you willing to accept that and dismiss the case? I mean, you never know where these things are going to go. Right now, it's income tax refund season, so a lot of money is coming in, and a lot of tenants want to redeem in a non-payment case by paying with their income tax refund. So habitability issues, proof of payment.
That's like you have, yeah, when you said you have paid.
You have paid, or, it's hard. Sometimes the tenant will say, I paid. It's like, well, I always ask, do you have any receipts? Do you have proof of the payment? And if they can't provide the proof, it ultimately is the burden of the tenant. So the landlord's going to say, you owe $1,000. If the tenant says, I paid it, and they don't have proof of that, the landlord's going to win every time. I had a case a few years back where the tenant, it was in a mobile home park, she was subletting from the owner, and she's like, I've paid directly to the I don't know, I think to the person she was paying or something like that. She couldn't find any receipts, so after she got evicted, guess what she found? She found all her receipts.
That's awful.
Yeah, so you never know where these things are going to go. And then for cause, again, it has to be something within the lease, and cause notices are pretty broad. You can take anything in the lease. If the tenant may or may not have violated it, a landlord can evict for that. So that all comes down later. That's all at trial. Are there sufficient grounds within the lease to terminate for that? It's usually a trial issue. And then the cause is alleged impermissible under the lease, but the lease clause is invalid because it violates Vermont law. So what would you say, like discrimination or
Yeah.
retaliation?
Yeah, those are good examples, yeah.
Those are the two big issues that come up all the time with tenant defenses, other than habitability, are retaliation by the landlord. And retaliation, I mean, say, for example, the tenant made a complaint to the city about a condition with the apartment. If the landlord then sends a notice out for no cause or an intent not to renew the lease, then that can be seen as retaliation under the law. There's a 90-day presumption that if the landlord sends some sort of no cause or non-renewal notice out within the 90 days, it is retaliation and your case can be dismissed. The other issues that come up are discrimination. usually disability, but pick any of the protected classes. My landlord is looking to evict me because I'm disabled, or I'm this, or I'm this religion, or whatever.
Or I had a child.
Or I have a child, or I receive public benefit, or there's a very long list of reasons why a tenant can claim discrimination. But again, those usually I find come up in, say, a no cause or a non-renewal type case. Rent is rent. So retaliation, I would argue that retaliation and discrimination are not a defense to a non-payment only, because if the rent is the rent, unless they're charging some outrageous amount of rent, was it an was it an uneven playing field? But I really don't see it come up in the rent.
It does make it more difficult, I think, when there's non-payment and those issues are also going on, but, certainly that's a counterclaim that can be raised later. Yeah.
And there are counterclaims. There's all sorts of things that go on in the landlord-tenant world. All righty. And there's more. Oh, and there's more. Yeah, so
Let's
if...
do this one a little quickly so we can get more to...
Okay, we're going to fly through this. So the case has to be filed where the rental unit is. I don't have that problem, but you must see it.
We've seen
You
it.
see it?
Yeah.
Really?
Yeah.
Because the landlord either is like, I live in Washington County, I'm just going to
Right.
file here,
Has
even
to
though
be
my
where the rental
apartment's-
unit is.
even though my apartment's in Burlington. And again, you have to attach a copy of the lease. The HAP contract, I don't think you really need to.
I'm of the position that the HAP contract has to be in there, but I know sometimes HAP contracts are massive.
Right.
And you might not need the whole thing, but
And a HAP contract is a housing assistance payment contract. It's usually with Section 8. And the only reason I say that is because usually those contracts are between the landlord and the housing authority.
Right.
Not so much
But
the
they are a
tenant.
party to the case, so that's why.
Yes, all right, well, I'm going to watch you. 'Cause, now she's going to try to toss me on these
It's
cases.
really only the lease addendum that has to be attached. There's a part of it that the housing regulations from HUD require to be attached to the lease, and that's the part of the HAP contract that pertains to the tenant's rights.
So David just raised that the most important thing to copy there, or to attach to your pleadings, is the HAP addendum. So that's something to look out for if it's a subsidized unit. Okay, go ahead.
All right. And Maggie talked about that, and the tenant was not served with a summons and complaint. Really?
Sometimes, yeah, but
Really?
usually that's like there's no return of service and it's pretty obvious, and the clerk
Oh.
might take that off, but,
Contents, too.
yeah.
And then you do have to be careful as far as service goes, that it's proper service. Because the tenant, I just had this come up, it's the craziest thing. The tenant said she never got served. And I've got 2 returns of service saying that she got served. Well, she was saying that she had medical issues and her friend took her rent and didn't pay it to the landlord. I'm like, what a really nice friend. I mean, we didn't get as far as, did the sheriff serve her or serve the friend? So, and then I had a case with a legal aid maybe a year or so ago where the sheriff improperly served the son who did not live at the unit. So under the service rules, which is Rule 4, you have to serve a person who actually lives there of suitable age and discretion. So in this case, the son actually, he was leaving, he was an adult son, actually told the sheriff he did not live there. And the sheriff served him anyways. I didn't know that. And then a motion to dismiss came in on the case. And of course, it was improper service. And then I had
Yeah.
issues
And
with
how
the
would you
sheriff's
know?
department.
Right, how would you know? You just get the return of service and think you're all set. Yeah.
Exactly, yep. But you may have that come up at an escrow hearing, because sometimes the sheriff shows up if there's a question as far as service. Because the sheriff will ask when, and I say he because all the sheriffs I deal with, it's like all men, all of them.
There is a woman now in Rutland.
Is there?
Yes.
Oh, Danielle. Danielle, she's like the only one. But if the sheriff goes over, the sheriff will ask, do you live here? And it's yes or no. If the answer is no, then he can't serve. But sometimes it comes up because the tenants will dispute service, and sometimes the sheriff will show up here at the last second for a hearing. All right, so we're up to, right, run into court,
Run into
hearing
court
and press.
pleadings.
So,
Oh, I'm pleadings. Yeah.
meetings, all right. So again, the landlord can file a motion at any point. It doesn't have to be with the case, it can be filed later. The the tenant can file a motion in opposition to it. Those rarely come in, every now and then they come in before the actual hearing, but there may be something in the court file with opposition, and again, usually that comes down to habitability. Those are the biggies. And then the actual hearing, you're entitled to for a rent escrow order. It's from the start of the case forward, so it's from service or filing of the case. It gets complicated. So the service or filing of the case, whichever occurs first. However, Judge Tour's rule is it's from the filing of the motion. So the rent escrow motion, when that's filed, that's when she calculates. It's different from county to county. A lot of the judges it's from whenever your tenant was served or when the case was filed, whichever happens first. That's when your clock starts ticking as far as how much rent the landlord can ask for to be paid into court. And it's from the rent from that point going forward. The rent that's owed prior to that is for another day, unless you work something out. But that's for another day. So for your actual rent escrow order, those are the numbers that you're looking at. And please don't do change. I hate change. There are some people who do change, like, oh, the rent escrow order is going to be for $2,506.40. Just make it and I see this all over the state. Not my cases, but I see it in other cases. And don't have change for the poor clerk's office to have to deal with, right? No change, because the tenant has to pay when they pay the court, has to pay by cash, bank check, or money order. So a lot of them do bring cash to the court. So make it easy on the clerks, don't do change. So negotiating the rent escrow order. When you look at how much is owed, because sometimes there is a delay from the time the motion is filed to you actually have your hearing, it could be several months, and by that point the tenant may not have that kind of money, especially if they're living day to day. They may not have it. You can negotiate with the landlord's attorney with, how about they pay X amount? It might be a smaller amount. You have that ability to negotiate what kind of order. You might get some landlords that are like, no way, I want it all. Okay, well, they're probably going to get it all, but your job is to see if you can negotiate something else. And then if you have to come out, if you can't agree on the order and you have to come talk to Judge Tour about it. So you might have to see Judge Tour just because you can't agree on the order. That an order's going to issue, but you disagree as far as how much and when. Judge Tour is really good about looking at the landlords and saying, how about a little more time, or would you agree to an extra week or two, or, it's kind of hard to say no to Judge Tour when she's looking at you. But, again, these are my clients. All right, back me up. We pretty much work it all out before, and we don't have these types of issues. But while I'm sitting in the courtroom and I see other attorneys at these hearings talking about how much is going to be paid when, that's something you can definitely negotiate. Sometimes I won't even worry about, say, half a month. We'll just start from the current month. It really depends on the situation. So if you've got a subsidized housing tenant and the rent is $300 and they have absolutely nothing, and you have a reasonable client, which a lot of my clients are very reasonable people, we'll just start the order from the present. We'll worry about the back later as far as getting them help with COTS or Community Action or Capstone or some of the agencies around the state. But this is all a negotiation, and you will learn some great negotiating skills, because you never know where the case is going to go. And if you're trying to negotiate something that's fair, and we all get along, but not everybody is so collegial, and there are some landlords. Is the rule still apply if the landlord doesn't have a lawyer, the tenant can't get help through the clinic?
Yeah, in other counties it's a little bit different, particularly in Rutland, where a lot of the landlords either are attorneys or were attorneys. So, and I think you're absolutely right. I think these orders are also a time to get creative, and it's important to talk to your client about, can you actually make this payment on this day? Because sometimes they'll say, well, I actually get paid, like here's when I get paid, and if it doesn't line up with the rent escrow order, well, maybe we can adjust that. I mean, if you just explain to landlord's counsel, this is when my client gets paid and this is when they can make the payment. I mean, if the landlord's goal is to get the money, then they might be flexible about that and be willing to do that. I've also seen, I don't know if you do this a lot, but depending on the landlord, sometimes they want the payment released as they come into the court, and sometimes the tenants are fine with that. Unless both parties agree, all that money is kept with the court clerk until there's the final resolution in the case, but if the parties consent, you can release it sooner. Sometimes there's reasons to do that.
Right.
Do you do that often?
No.
No.
Because it's just, I don't know, it's burdensome, isn't it, to the clerk's office? Because I know they
We
get a
do
little.
only do it on the clerk's schedule, though.
Yeah, I mean, because, Michael, the floor is yours.
It's kind of like the three people with the different keys to the nuclear codes, where I have to get the books from the finance guy, who then gives it to me, who writes the check, who gives it to the core operations manager, who then needs to review everything, sign it, who then needs to give it back to the finance guy to enter it all, because the check's not going to clear with the bank unless we enter it in and give the okay ahead of time, who then gives it back to me to then enter it all into the system.
Okay, so don't do that in Chittenden County, but there are other counties where we do that.
Or
Don't do it here.
get your final hearing sooner rather than later, because I know it's hard for you because it takes time, like Washington County, like Jane will cut the check the same day, but it's different. And I have had a court bounce a check, an escrow check once. Yeah, that was hilarious. So my client calls me, the check bounced. I'm like, what? It's the court check. It didn't bounce. Oh, it bounced, all right. They didn't put a code in when they put it in the computer, so you... Did I get a writ? Oh my gosh. But I was gonna say with Maggie, know what your client's income is and their ability to pay. I mean, I know, I've been at this a long time. If a tenant is on Social Security disability or Social Security, the checks come in a certain day of the month. You shouldn't be agreeing to any escrow order on the first of the month because they don't have their money. It's just, and again, I play fair, but not everybody plays fair. But just make sure you know when they're gonna have their income and that it's actually doable for them to do that, to get the payment in.
That I think is where and I think this will happen most frequently with pro se landlords. If they say, I want it in the first and I'm not budging, if you tell the judge, my client's Social Security comes in after the first, can we make it due on the 5th? I think that's where the judge will utilize discretion and just say, it's on the 5th. Like, I'm not gonna be unreasonable about that.
Exactly. And then you might also want to consider if the tenant has to mail it in. The best case scenario is if they can actually bring the payment to the court, but especially in some of the more rural counties, it's just not so easy. Or I have a lot of tenants that either don't have cars and they have to take the bus or SSTA or whatever, so they will mail it to the court. You want to make sure you have enough time from when they get their payment to mail it to get it to the court in time. What else we got? Consequences. I think we've been talking about the consequences, which is you don't pay, you're out. I mean, it's that fast. And then there's always a reason for a motion at the last minute. If the writ issues as to why the writ should be stayed, some of the motions that usually come up, either a government check was delayed. If that's the case and you can show that the check was delayed, then the court will either stay the writ pending the payment. But those don't come up really that often anymore because the order was negotiated. And if you negotiated the order, the judge is looking at it going, that's it. The judge will explain to the tenants that you have to make these payments or you're out, that I just checked the court record and if that payment is not here, then you're moving. So Judge Tour is very good about explaining the orders to the tenants. So they have to comply with it. It's a very serious order if they don't.
I'm going to go quickly just through habitability complaints. We did talk about this a little bit earlier, that if your tenant shows up with a complaint about habitability, sometimes that claim is ready to bring if they've talked to the landlord about it, if they had the health inspector come out, if they have a report. Most people, I think, are not prepared with that information, but if they do have it, that's a great time to proceed then. And it's also important to look at the seriousness of the problem. And I usually kind of look at, does this affect health and safety and the tenant's ability to continue to live there safely? So things like mold in the bathroom, that might not be a safety. I mean, it could be there is toxic mold, but if it's in a bathroom, it's likely from moisture. So is that something you want to do a contested hearing on. Like, we have no way to test that mold or have an expert testify as to what it is at rent escrow. It might not be something that's worth raising in a contested hearing. And also, you need to look at the losses that the tenant has suffered as a result of this problem. And so my word of caution is about having insufficient evidence or a not serious enough problem. I mean, the reason why this would come up at rent escrow is this a habitability problem that's so serious that the apartment is no longer worth the rent that's being charged? So should the rent into court order be less money than the contract rent?
So you have two avenues on that. So one, you can negotiate with the landlord's lawyer for a
Right.
lower rent.
Right.
So you don't have to come out and have a contested hearing. You can ask the landlord's attorney, there's this issue, that issue, would you be willing to accept, if the rent's $1,000, would you accept $800 until the case is resolved? Because the landlord is not waiving their claim for the rent. They're just agreeing to a lower amount being paid into court. So that you can negotiate as well.
That's true. And I know Judge Tour says this, if you're looking for a rent escrow order reduction, I think it's always important to be prepared to tell the judge what you want. I will never forget being in law school and having a judge say to a lawyer, so what is it you want me to do? And the lawyer was like, I don't, and I was like, oh gosh, you need an answer to that question, right?
She's scarred for life.
Right. So I was like, whoa, you need to know what you're asking for. And if that's a reduction, I think, it does help the judge to say, what's the dollar amount of a reduction you're looking for?
It's good to know that different judges, they're all different.
That's
So Judge Tour will take into consideration habitability issues on a rent reduction, but some judges out there are like, you know what, you're just going to pay the whole amount of rent into court. We're going to have a final hearing. If I find in the tenant's favor, then that you at least have all the money there to redeem. If I find for your landlord, then you're going to be short. You might be short. So different judges take different views, and you learn how different judges do it as they
Right.
go along.
Yeah, especially if you come to all the clinics.
Yes,
You really get
can
to
learn
know all of the
them.
judges in all the other counties. So I'm just going to say now, I think what I would like to do is the common rent escrow situations and settlements. We'll drop the last 3 slides because I think we should spend the rest of it on that. This is a meaty part. So I sort of put together what I think are the most common rent escrow situations that you will come across. The fact patterns for these are going to be very wildly different, like how folks are in these situations, but it boils down to these 4. The first one is the tenant can't pay and or the apartment is not affordable, and you're just not going to be able to save the tenancy. It's not going to happen. We can't get them more income. We can't recover from an arrearage of $8,000. I mean, I think we've all seen arrearages that are really high. I think the record might be like around $30,000 when a landlord
What?
forgot their tenant was there.
No, I have
So-
the record. I have the record.
You did. What is it?
$150,000.
Oh my God.
The rent was $50,000 a month.
No.
I don't even know how that happens. How does that happen?
150,000. I think Judge Shore almost had a heart attack. It was an elderly landlord, really nice guy. The
Oh
tenant
my
had
God.
serious health issues. He's like, okay, if you want to subsidize the tenant, that's fine. But then his wife found out about it. And that's when they both came to see me. So
Okay,
I had
that's
an
the record.
$80,000 too. So,
Oh my God.
Yeah.
Okay. You win. You win. But in any event, there's sort of no coming back from this.
Right, yes.
The solution there, I think, is to negotiate a stipulated move-out date. And whenever we are looking at that, we're usually looking to see if the landlord will waive the back rent. Generally, that is, I don't think anyone that's owed money really likes the idea of parting with that. But so many of our clients are judgment proof. They are getting on Social Security, they're getting reach up, they're earning a wage, but they're receiving some other benefit. So their income is not collectible. So it just, most of the time I think the landlord is like, I just would like my apartment back. I'm willing to let go of those claims. You can draft a stipulation that includes a move out date, that it can include a writ of possession for the next day, waiver of the back rent. It's also important, I think, I do have a list of what you should include in a stip, but what's going to happen to property that's left behind after a move out? How are you going to exchange keys? What's going to happen with the security deposit? Try to include all of those things in your stip. Or, sometimes I'll have that situation and the client will say, I can't move. I don't have a way to do that right now. Sometimes that's a time where you do enter someone into a rent escrow order. they may or may not be able to pay it, but because they can't commit to that move-out date, just get them into a rent escrow order until they can come up with some sort of a plan.
And with a tenant that is judgment-proof, a negotiated move-out is usually the better way to go, because I can pitch that to the landlord. You're never going to collect it, waive it, I can have your apartment back in less than, about 30 days, and then
Right.
you got to gauge what's reasonable.
Right.
Can they be out in a week, 2 weeks, 30 days?
Right. It all depends on
you
your
can
client's
negotiate it,
goals.
because then they'll leave owing nothing, which will prohibit them from a subsidy down the road if they leave owing nothing, so.
Exactly. And, something that is in a previous slide, but we didn't talk too much about, is that a great goal for the clinic is that if you've got a tenant in this situation, what we want to try to avoid is creating a person that's now hard to house. So we've got, someone with a large judgment against them, they were evicted via a writ. A lot of times we'll consent to a writ, but there's a move-out date, and the person's going to comply with that. That person was not evicted. There was an agreement for that person to vacate. So we want to put them in a position where this is not going to be sort of a stain on their rental history that's going to follow them long-term.
And it's all public record. All of it is, any landlord who searches any tenant can find it.
And the next situation is the tenant can pay rent, but catching up will be hard. As Nadine mentioned, right now it's tax refund season, so a lot of my clients right now are using that to get caught up. And it's, this is sort of a time of year where it's a lot easier for folks to do that. It sort of doesn't happen if it's not the spring. But, if it's going to be hard, that's when we look at community resources or some sort of payment plan. I have done this once and I'm not going to do it again, but when I do a rent escrow order, I just have that be for rent. If there's a repayment on top of that, I don't put that in a court order, just to not overcommit somebody, but still get them on a payment plan. The last two, tenant has a rental subsidy. That's where, clinic staff can help. There's issues about how much rent should be ordered into court if there's a subsidy. Really we only want to commit the person to their tenant portion, not the full freight, especially if it's being paid for by the housing authority. And this is where if we're negotiating something, we want to negotiate a neutral reference from the landlord, a neutral landlord certificate, compliance with the rules, things like that. And the last situation, sometimes people will come to rent escrow and say, I'm gone. Or
They do.
I'm half out, or the moving truck's coming
Right.
today.
Or I'm moving tomorrow.
Right.
Yeah.
And then, possession is not an issue. If someone has left, a judge will not order rent into court for that person because that's for prospective rent. So they're not going to issue an order for rent going forward if you're not living there. But then the remaining issue is money damages. So at that point, you might say, look, they're leaving today. You get your apartment back. Can we negotiate a waiver and see about resolving the case that way? So I think the last bit of the presentation, I think what we're going to focus on is negotiating those settlements and working with opposing counsel to do that. I think this slide is kind of duplicative of what we just talked about, but in drafting a step.
Can I add one thing?
Yeah, sure.
So with Judge Tour, again, all the judges are different, but Judge Tour, if the tenant has been paying the current rent, so by the time you get to the rent escrow hearing, it's say 2 months out. If the tenant's paid rent that month, maybe paid rent the month before, she will not order it. She will not order a rent escrow order. So you should check the
Or
history.
not for those 2 months, right? But for
No,
going
She
forward.
won't issue an order.
Really?
Period. Do you
Oh.
not know that?
No, I
Wow.
did not know that.
Let me share, Maggie. So, that's great. So if they've been if they've been making the effort and paying their current rent, she will not issue the rent escrow order. So usually your landlord's attorney will have a printout for the larger clients. There will be an accounting. I always hand over accountings, and you will be able to see what the history of the payments is on that. I won't bring a rent escrow if they've been paying the current rent, but other landlords, you might want to check and see what they're doing.
Oh, that's good to know. So for drafting a stipulation, in the form section, I bring these to every single clinic. I have blank rent escrow orders, so if you agree to an order, you fill in the dates that the payments are due, the amounts, but I also just have a blank form that's called stipulation and a bunch of lines. That's where you can fill out what the agreement is. And so this is sort of a checklist of things that you want to include. I also included on the next slide a sample stipulation, which I'm realizing that is teeny tiny, right?
Yeah.
That's so small. Okay.
Oh, my God, yeah.
And it's even smaller in the handout. So I will get everyone
test.
the sample stipulation, but I'll read it very quickly. So in the sample stip, it's the parties in this case through their attorneys agree to the following terms. Defendant agrees to vacate subject property at this address by the end of this date. Parties agree to the issuance of a writ to issue immediately, but which shall be executable only after the next day, February 1. Parties agree that service of the writ can happen in court today and no further service costs will be incurred. Plaintiff agrees to waive any alleged back rent and costs. Defendant agrees to leave the unit broom clean and free from debris and personal property. That's kind of what all of my stips tend to look like. I think they can get even more detailed if you've got, what's going to happen with the keys. I mean, sometimes we work out that. That one was silent on the security deposit. I think it's good to have that disposed of in some way.
So and don't feel like you're alone, because if the landlord has an attorney, we'll do deals right here. I'll call my office, and someday we'll be able to, print here and do it. But I like
Someday,
email to the
I would
clerk's
like
office.
to get a portable printer, and I'm going to try to find a way to do
You
that.
know what Evan Parkhurst does, he brings his laptop.
Yeah, like Greg will
The
do
clerk
it.
can do that?
Yeah. Oh, yeah.
Okay, that's
Or
good to
email
know.
What Evan does, he brings his laptop, he types up the stip, sends it, emails it to the clerk, and they print it out for him, so we have it.
So again.
That's great. In other counties, I just handwrite it, and if
So
you have
can
okay
handwrite.
write. Yeah,
Or,
you can.
again, every county is different, like Michael or Zach or Greg, the court officer, they're all great. But Washington County, Judge Teachout has an issue with that. So just make sure you get approval from the clerk's office.
We do it, though. And
Shh, I know, they'll be like, shh, don't, oh my
Okay.
gosh. I shouldn't be saying, because we're on camera right now.
I know.
Sorry. Okay, but
I think it's because it's the clinic. I think
Yeah.
that might be where there's some flexibility, right?
Yes.
With handwriting things. Yeah.
Yep, but, I'll do either a move-out agreement, I have my own forms, or you can also negotiate a repayment agreement. And some landlords are open to that, and Judge Tour does allow 12 months. I think there's only 2 judges in the state that do not allow repayment agreements, but most of them do.
Yeah.
And a repayment agreement is usually the rent has to be paid by this date, X amount on the back, and the dates of payment, and you have to make the payments. And if you don't, then or the landlord can petition the court that there's a default under the agreement, and you would be entitled to a writ. So if a tenant has just kind of got behind a little bit, is back to work, they've got enough income to sustain the housing, see if the landlord would be open to a repayment agreement, because that way the
Yeah.
landlord will get the rent every month. If not, the landlord has the backup that the tenant will be evicted if they don't make the payments. So I do a lot of court-ordered repayment agreements.
And sometimes I do something that I think is sort of a hybrid between a rent escrow order and a stipulation. And some judges want, if you're going to do that, some judges actually want both a rent escrow order and a stipulation, but some will accept the stipulation. What I mean by that is sometimes if we've agreed to a move-out date, the tenant wants, let's say 2 months or 3 months, and the landlord's willing to agree to that. I think, a waiver of back rent is not an impossible thing to get if the move-out date is going to come kind of soon. But, if you're asking for a move-out date further into the future, sometimes the landlord will say, that's fine, you can have your 2 or 3 months, but can you pay me something for those months? And that's not really a wholly unreasonable request most of the time. So sometimes our stipulation or hybrid rent escrow and stip will include some payments made to the court. I know in rent escrow format, it could be, whatever amount you agree to, and then that leads up to a move-out date, or, if you've paid it, done a repayment plan, paid it all back, then I'll go ahead and dismiss. If you're going to be agreeing to a move-out date that is more than 60 days in the future, writs of possession are you have 60 days to serve them, and then they expire. So the way we deal with that with the clinic is sometimes I have just stayed in the case and agreed to accept service of the writ afterwards. If you as a volunteer attorney just don't want to do that, and we completely understand if you don't, you can let us know, and maybe one of us can agree to accept service of the writ. I will not mind that. We just want to make sure that there's a way to get that served if it exceeds the amount of time that a writ would be valid for. So that's just sort of something to flag. Anything else for drafting? I mean, how do you feel like negotiations between us? I feel like these are the main things that we're looking at, right? And, you know, I think that if we cover most of this stuff, I mean, I have to say, like, I deal with keys, I think maybe almost never, but if you can agree to, like, here's how the keys are going to be exchanged, you avoid problems in the future. And I also think security deposit, if your client owes something like $5,000 or $6,000 and they agreed that the landlord can keep the security deposit, that issue doesn't have to be dealt with any further. And sometimes the landlord thinks, okay, I don't have to deal with it. I get to keep this little bit of money. Maybe if they're not as inclined to waive back rent, that might make them a little bit more inclined to do so. Since
Landlords always get the deposit in these deals. Always.
not always, right?
Mine do.
I mean,
You want me to waive $6,000 in rent?
Right.
We're keeping the deposit. But, so that's, I guess my words of advice would be, when you go in and you meet with the tenant client, not to get drawn into the whole saga, because there's only a certain amount of time. And if you're going to try to negotiate a deal, you need to be quick about it, because, you know, like my subsidized housing providers, they are, you know, they're patient people, but my market rate landlords, they're paying me to be here, so they don't want to sit around for 2 hours at the courthouse unless we get a solid deal. So just keep that in mind. Try to keep them focused. Find out what the tenant would like to do or what they're thinking of. They'll tell you right off the bat, I want out or I want to stay. And then you kind of go from there. And deals can be made, and also keep in mind, you might be able to start negotiating a deal and we can take it from there, because sometimes I'll say, I don't have time right now to draft a stipulation, but I will mail it to the tenant, or Maggie or David will be involved, which is great, and I just email it to them and we wrap it up later. So don't feel like you have to get it all done at the escrow hearing, so.
and I think to your point about, you know, we don't have unlimited time, I mean, you know, again, a tenant is talking about something that's deeply personal to them, which is where they live. And so it's not that those issues are unimportant. It's just that they're not really going to help us so much at rent escrow. So I think the role play that you'll see a little bit later will focus on that. But, you know, it's a delicate balance. Again, you are all lawyers. You know, sometimes your client wants to tell you a ton of stuff when you just really need to know these 3 critical things. And that's where, you know, that's something that you already know how to do. And, you know, the training is sort of designed to help you pull out, you know, what do I need to know for this hearing? And of course, you know, things like habitability, or I think this landlord is treating me poorly. I mean, if those things are not necessarily something that's relevant at rent escrow, it's important to let that person know, we don't need to hear about it today, not because it doesn't matter, but just because at this hearing, we don't need to know about it. But these are issues that you can raise later. You can respond to some of these things in your answer. You can discuss them in your counterclaims. It's just not relevant today. Not that it's just not relevant, period. But it is sort of a delicate balance. You know, you want to maintain that trust with your client, but also hone the conversation and have it be as productive as possible.
Or if you need a break, or you feel you need to get out of the room for a minute, you can just say, I need to go talk to your landlord's attorney. That will break the conversation, and then really come out and see the landlord's attorney, because I will take it upon myself, if I feel that you're in the room a little too long, I will go knock and check and see how things are going, because I'm trying to move it along, and I'm trying to help you, because a lot of times my tenants, I've already had interaction with them before they get to court. A lot of times they'll call the office, so just to try to keep things moving along, because they will dominate your time. They will tell you their entire life story, and you need to focus on the issues. So whatever I can do to help you and us work it out, that would be great.
And and clinic staff, and I think certainly the court officer is also looking to keep the schedule moving. So we're gonna toss away the answer and counterclaim slides, because generally clinic staff don't need to worry about those things. That information is there for you if you need it. So we're gonna wrap up this part of the presentation, but I just want to say again, thank you everyone for coming. I really hope you consider volunteering and participating at the clinic. There's information about who you can direct those questions to, and the next clinic dates are here. I mean, I realize that this PowerPoint is going to be obsolete in a month or 2 months, but those are the dates coming up in Washington, Chittenden, Rutland, and Addison counties, and as more dates come out in the expansion counties, I'm in touch with volunteers. Please get added to the list. and we'd love to see you at any of these clinics. So I think at this point, we'll just take a brief 5-minute break.
Oh, yeah. Two things, well,
Yeah.
one thing. So I've been participating in the clinic since it started, and I can tell you that I've seen very inexperienced attorneys start with the clinic, and I've watched them grow with their participation in the clinic. And they were all nervous at the beginning, and I've watched them blossom, and now they are very effective attorneys at these clinics, and I look forward to, it's hard for the landlord's attorney, especially if we don't know you and we haven't worked with you before. It's like, oh, how's it going to go? But I've watched our relationships develop over the last 4 years, and some of the attorneys that participate in these clinics have been all 4 years or have been the last year or two, but I've watched them grow and blossom as attorneys, and their negotiating ability and their focus on the law and what's the right thing to do for your client.
And it gets you into court.
And it gets you into court. It gets you communicating with people. There's a lot of benefits to it. So if you have a practice that really doesn't get you into court that much, this will get you here. So it is a great program. It's going well.
I'm
So
glad you
thanks for
think
coming
that.
today.
Yeah, thank you very much
You
for
have
coming.
questions?
Oh, yeah, there's a couple questions.
I was wondering if I might be able to take your picture for our website.
We can do that later. Yeah.
Photo ops.
Do it later?
Yeah.
Okay.
Question in the back.
Do you know the times for the starts of the clinics that are coming up?
All of them are, all of them are 8:30 except for Addison, which starts at 1 o'clock in the afternoon.
And Chittenden's always on a Tuesday. It depends, the first and third with Judge Tour.
Switch it to one now. Like they did once ago.
Follow Michael. Poor Michael has to schedule all these things, so.
Okay.
Call Michael, he'll tell you.
So I think we'll go ahead and do our 5-minute break.
5 minutes.
Yep.
Just
And
5
then we'll
minutes.
come back in 5 minutes for hearing from a volunteer.